Welcome to today's episode of the EB-5 Insight podcast. Today, we will discuss the importance of a strong I-526E filing as it relates to the upcoming EB-5 grandfathering deadline, and as it relates to current scrutiny towards these petitions from a federal government level. Our guest today is attorney Ricky Murray, an immigration attorney who previously served as deputy chief of the Immigrant Investor Program Office, where he directed policy and operations, as well as presenting at conferences nationwide about EB-5 policies. Ricky spent a total of 18 years working for the U.S. government, during which time he has witnessed how the top-down pressure on EB-5 petitions has been changing over time. Today, he brings that same knowledge and dedication to his law practice, Jet Global Solutions, where he advises and represents clients navigating the U.S. immigration system. So without any further ado, let's jump into our discussion. Ricky, welcome, and thank you so much for joining us today to break down, what EB-5 investors need to know right now.
Yeah, thanks so much for having me.
Absolutely. If you don't mind, I'd like to just jump right into the questions. I want to definitely discuss in depth some of this top-down scrutiny we're seeing from USCIS on EB-5 petitions, how they relate to the upcoming grandfathering deadline, and some important issues like that. So, before we jump into some of the more current topical issues, I want to go back to the Reform and Integrity Act of 2022. What changes have you noticed in USCIS source of funds expectations since RIA was enacted in 2022?
Yeah, so one of the biggest changes in RIA was actually really kind of the explanation about how they could look into funds. So things like gifts and loans, things that weren't clearly allowed or necessarily disallowed with USCIS previously, really were kind of put together for a framework. And especially in regard to the changes, one of the areas that's been specifically enumerated in RIA is really being able to look back on if money is gifted for your investment, you are expected to be able to go through the documentation and source of funds of the giftor, so the person giving that gift. And that wasn't something that was documented pre-RIA. So that's something that USCIS had a lot of different latitude and just wasn't able to dig into those funds. I mean, one of the parts that really allowed them to go back into that source of funds was the way RIA was worded.
Right. And so you mentioned that, especially when we see, a source of funds or the capital investment coming from a gift, or, especially from a family member, I would imagine is what you're most commonly seeing, like a parent or something like that. The importance of the background and the source of funds documentation of the giftor. Is that correct?
Absolutely. I mean, before, they were able to minorly look into it, but after RIA came out, the expectation is that you need the same source of funds documents from the giftor that if that was your money. So, I mean, you're really going to need a lot of documentation from the giftor to be able to carry the burden that USCIS expects.
Right. So it sounds like essentially we're looking at double the work, double the information, double the financial history needing to be provided, correct?
Yeah, and especially as you're starting out the source of funds process, I mean, ensuring that the giftor is able and willing to give you that documentation is a huge piece of the puzzle, because in many cases, once they understand how much documentation is actually required, in many cases, people do step back and are saying, I'm not sure if I am going to be able to or want to provide all that documentation to the government. And if that happens, unfortunately, that's not a viable source of funds.
Right. So understanding it's not just about a loan of the actual capital investment. It's, are you willing to give up, all of this information that's needed, which is more information than ever right now for, a concise EB-5 petition is what we'll have to offer up. Yeah. Well, we recently both attended the AILA EB-5 virtual conference, during which you were a panelist and you discussed some of the current scrutiny that exists on EB-5 petitions that are filed with USCIS. With these reports of, this sort of top-down increased scrutiny, how has the source of funds standard changed from earlier years, say right after RIA to now?
Yeah, so the reality under this administration is just the U.S. immigration landscape has changed. I mean, it's just stricter. And I think that shows in all parts of immigration, but especially in EB-5. And now in EB-5, I kind of look at it as like a baseball metaphor. Like before, like preponderance of the evidence is a standard. So that's 50 and a feather, like saying that it's more likely than not that this is true and correct and lawful. So before, like with that baseball metaphor, it used to be tie always went to the investor. And now the tie always goes to the government. So if you're not actually being able to show the specific documentation or the letter of the law that allows what you're doing, they're not going to look favorably upon that. I mean, before, very much within USCIS, there was an expectation of the adjudicators being able to use a little bit more of, I'll call it free will, but being able to kind of look at a source of funds objectively and holistically and be able to say, yes, I do think that made the burden. Under this administration, there very much is sort of a fear of repercussion within the government. So people don't want to make the wrong decision and grant something that potentially can come back and bite them in the butt. So there's very much a sort of first instinct to deny rather than approve, which hasn't always been the case.
So if that first instinct is to deny or, issue a notice of intent to deny or something like that, in your opinion, what specific documentation gaps are most often leading to these direct denials or direct notice of intent to deny instead of what used to be RFEs in recent I-526E cases?
Yeah, to me, the place that's really becoming the most prevalent is sort of that path of funds, and that's how the funds get to the United States. How are they coming from the country, in many cases, into the new commercial enterprise bank account in the United States? And many of the countries that are large within the EB-5 population have currency restrictions within them. China, Vietnam has some. So getting the money out of those countries is really hard. And one of the expectations is really providing the documentation to show each step of the way of how those funds get to the United States. And I think that's an area where it was always important, but it wasn't necessarily having to be documented as heavily and as strictly as it is now.
Sure. So I'm glad that you bring that up, the sort of cross-country, capital transfers or funds transfers. What do investors need to watch out for or include or, make sure is included when their source of funds involves moving through multiple countries or currency transfers?
Yeah, so there are a lot of areas to touch on. I mean, one of the things is like a broken money trail. You really need to be able to show exactly which accounts they go into. So if you're moving money from China, say, if that money goes to Hong Kong first, you need to show the bank accounts of it going into the Hong Kong account and leaving the Hong Kong account to the United States. And you just really showing that whole trail. If you show the money going from the China account into Hong Kong, but then mysteriously the money is coming out of Macau into the United States, there's going to be questions about, so where was the money in between those times? Also, third-party accounts, like many times they're using friends and family accounts in order to get money out. That's potentially okay, but they really need to explain why, whose account it is, and how that really ties into them getting the money into the United States. If you don't explain that to them and you leave that up to the imagination of the adjudicator, they many times will see a worst case scenario. So it's just really important to explain why you're doing everything you're doing. Some other things are currency conversion issues, where the money doesn't look like the additional money is there or less money is there. They call into question. I mean, there's always a general currency rate, So if all of a sudden that money is far more than any normal business bank or entity would give for that, how did that money get infused there? So looking at that. Also timing gaps. If you're looking at a sense of how long it's taking to get to the United States, if it stalls in a place for a significant amount of time, you're going to have to explain why. Like you can't just rely on having those documents. So much of it's really telling the story and explaining how it works. How did the money necessarily get through all those steps, and why did it go to the places it did?
Right. So, for investors that say have, long or complex work histories or, cross-country transfers or complex financial histories, how many years of financial records does USCIS generally expect to see?
So the reality is there's no right answer to that. It really is going to depend on a sort of a case by case analysis. I mean, so for anything, the original funds are the most important piece. So let's just use a sale of property. If you sell a property in Vietnam, let's say, so obviously you may get the $800,000 investment out of that sale, but the interest for USCIS isn't the sale. It's how did you get that property in the first place? You obviously paid a down payment, you had a mortgage. So how were those funds accumulated to do that? And I think that length of time is going to be what USCIS is most interested in. If you were lucky enough to have a very well-paying job and you were able to afford that property after just 1 or 2 years of income accumulation, then you may not need to go further than that. But if this is something that took you 10 years, 15 years to save up to be able to buy that property, USCIS is then going to be able to expect that 10 to 15 years of documentation. So it's going to be different for everyone, but that sort of initial contribution, either to buy a property, to buy a business, to whatever you're working with, like that time frame is really the one that's important to focus on when you're starting to accumulate documentation. And unfortunately, that's also in many cases the hardest time to get the documentation for, because in many cases these are decades ago in some cases.
Sure.
So like starting early and getting that documentation is vital to the process.
So it's less so about expecting a set number of years in the past and more so an understanding of, if it's coming from a particular asset or particular source, really what is the origin of that source or the path that got you to the current state of that source, so to speak.
Yeah, absolutely. I think so. Great.
Got it. So, to sort of build on that, how important is it for a potential investor to understand the amount of time a proper source of funds package can take to build? I mean, how early should a serious EB-5 investor start gathering this documentation for their source of funds, especially with this grandfathering deadline in September right around the corner?
Yeah, the grandfathering deadline, I think, is important to mention. I mean, that's September 30th of this year. But the reality is, though 6 months sounds like a lot of time, in EB-5 terms, that's simply not a lot of time. It takes a lot of time to do the source of funds. And this, I think, if you talk to an immigration attorney, like they'll say source of funds is probably the more important thing than the actual picking of the project. But I think many of people entering the EB-5 space as an investor, their first instinct is, let me pick a project, see if I find a project that I'm interested in that fits my needs and the timelines I'm looking at, then I'll figure out the source of funds. And that's simply because the reality is USCIS at some levels is sort of unreasonable about the documentation that they're expecting. I mean, but that is the universe we're working with. And because of that sort of unrealistic nature of what they need, it takes so much more time than any investor is expecting to get that documentation together. Generally, when investors come to me, they think, oh, that just came from income, or it all came from this sold property. I can easily get the sale document for that asset. Like this won't be hard. That's not going to be my holdup. And unfortunately, in many times, that is the holdup and the piece that takes longer. And the one thing I think, as we're reaching that grandfathering date too, this summer is going to be a rush for EB-5. I mean, there's a lot of concern about what's going to happen to the program. And that's the only guaranteed date that you'll be able to really fulfill that immigration journey. And so these projects are going to fill up quick. If you're not done source of funds, you may not be able to get into the projects that you've looked at and are really fit your needs, and you may be forced into different projects. So again, like I think source of funds really needs to be that priority for a serious investor, and then move on to the project side of it.
Right. Well, so to sort of build on the point that you're making here, from the regional center side, like ourselves, when working with prospective investors who are new to the source of funds process and all that it entails, you kind of hit on this already, but what sort of guidance should we be offering before investors engage in an immigration attorney and really decide to move forward with, the EB-5 process and filing a petition, especially in this time of increased scrutiny? Is it just guidance towards this process is probably going to take longer than you're going to expect. Plan your project timing around that, understanding it may be a few months or even more before you're ready to file and pick a project. What sort of guidance do you think should be coming from the regional center side as someone who's seeing this increased scrutiny on these petitions?
Yeah, I think you're right. I do think, yeah, it's really just to engage with that attorney, the immigration attorney, and especially an EB-5 trained attorney early, so they can really sort of map out how long that's going to take, to give them a reasonable expectation of sort of what time frame them are they really going to be ready to actually invest in projects, because that's when you can work with the regional center and say, the reality is there's only 3 spots left in this project, and it's going to take about a month for the source of funds. That may not be a reality for you. So let's actually, as the regional center, say, these are the projects that are now available that are probably more in your timeline, and to sort of just have those conversations to manage expectations, I think is an important part of that process.
Sure. So assuming that, the EB-5 program is, let's say securely reinstated, after September of 2027 and the program, does not sunset, it continues, how, as we shift administrations, is there any discussion of a trend of this scrutiny on I-526E petitions? Is it believed among immigration attorneys that this scrutiny at this level is always going to exist, where the source of funds package has to be this incredibly tight knit? Is there a belief that perhaps it could shift to be, maybe a little bit more towards what it was like post-RIA? What is the belief around the trend of this scrutiny on these petitions?
So in my opinion, this is very administration based. I mean, I think every administration has different immigration priorities and their agenda is different in that area.
Right.
And so I don't think it's unreasonable if we have a change of administration and a different party takes the presidency, that it may go back to sort of a little bit more of a reasonable, relaxed view. It's not to say that there's not going to be a lot of scrutiny on source of funds. I mean, the RIA made it very clear that the source of funds is an integral part of the EB-5 adjudication and process to ensure that those are lawful funds entering the United States. So that's not going to go away, but definitely sort of back to the baseball metaphor, I do think that tie can go back to the investor in a different immigration landscape going forward.
Right. I wanted to also touch on, from the regional center side or the project side, with some of the inventory management announcements from USCIS, we were already seeing a little bit of a rush of rural EB-5 project offerings to market. And, I would imagine that's only going to increase now with this inventory management announcement. With that said, how important is it for regional centers to really perform thorough due diligence on, their financing and on their projects before, just rushing rural offerings to market?
I think that's incredibly important. I think regional centers owe that duty to their investors to make sure that they have a thoroughly vetted project that they are comfortable with the due diligence on. And one thing from my experience too, just sort of taking that to the investor side of the house, the fact that you have a 956F approval isn't from USCIS isn't saying that that's necessarily a good project. That's saying the project is USCIS compliant. And those are two wildly different things. So I think it's really important that the regional centers do their due diligence for the investors to make sure that these are safe, reasonable projects for them. And I think for the investors, it's important to understand that they have a duty to themselves. When you're investing that significant amount of money, they really need to dig into the projects additionally and do that research to make sure that they're comfortable with the exit strategy, with the job creation, with just the project's reasonableness overall. I mean, these are very important things in picking a project.
Right. So just to nitpick on that a little bit, what, based on what you've seen in your time as an immigration attorney, is a project that separates itself from just being USCIS compliant with their 956F filing, and a project that really has proper due diligence, has certain, job creation metrics or economic modeling that, is well over, say, a minimum, 10 jobs per EB-5 investor. What are some of the differentiators between being USCIS compliant and being a proper good project that, clearly is set up with good due diligence?
Yeah, for me, a lot looks at the exit strategy and really talking about how that money is actually going to be returned. I mean, how are they planning on winding down that business? And many times these are loans. Like, how are they expecting to get the loans repaid? I mean, so to me, exit strategy is a very interesting one, because especially under RIA, where the sustainment period is now 2 years. Previously, that money potentially was tied up for many years because you had to wait till age 29. Under RIA, where it's only that 2 year sustainment period, there's a reality of you getting that money back in a reasonable amount of time. So understanding how they plan to do that is a really important part of the puzzle, and one that I don't think necessarily by prospective investors is always taken as important. I mean, they do look at the job creation numbers, which it is very important to have a job cushion. I mean,
Right.
the closer you get, it does make you nervous, and it's with some of it too. Just really how they set up the whole project, and especially with job creation, tying that to construction, knowing that money. Those jobs are a little more secure, rather than tying it to pro forma numbers, where you're looking at something and it's basically saying that these are potential, like, we need this amount of revenue in order to get these jobs. I mean, that at some level, even though they're educated guesses, they are guesses to an extent. They're hypothetical. Right. So, I mean, really understanding how that project's put together. And I do think it also helps, depending on how much developer skin is in the game as well. I mean, is an important fact of the matter, because I mean, the more they have in the game also gives them more incentive to make sure that project is a reasonable one, and one that they think is going to be successful and will succeed.
Absolutely. Well, I want to wrap up with a question here that's going to seem very simple in relation to some of the concepts that we've discussed already, but just simply put, in your opinion, what are the specific gaps, whether it's documentation or providing enough documentation about the path? What are the specific things that most often lead to some of these direct notice of intent to denies, or direct denials, instead of RFEs, or instead of a well put together successful package in most cases? I mean, what is really separating a source of funds package that gets approved from one that triggers or an RFE or gets denied, to put it simply?
Yeah, so I think the approval packages, I really kind of look at the 3 C's. So continuity, clarity, and credibility. I mean, those are the 3 things you need to avoid RFEs and avoid issues. I mean, it's really important that you're clear about the whole story, and you telling the whole story, and you're able to, throughout the whole entire process, document, and that gives you the credibility you need to get approved. I mean, it's the failure to provide that story and that understanding of how that source of funds works and how that path of funds works. That's where you're going to get RFEs and denials. And especially now, I think the straight to denial, especially USCIS is looking more closely than ever at approval when filed. So if you have any legal deficiencies, and not just an evidentiary gap, if you have a legal deficiency, they'll go straight to denial. And that wasn't always the case. And one thing that, as we're coming up to the grandfathering date, that I think is important, previously the program has lapsed. The regional center lapsed in 2021. When that happened, right before that deadline, USCIS had explained they were going to put case on hold. So at the last minute, people were just putting in what they call skeletal filings, which mean had very little information. They figured they'll get an RFE when the time comes, and they'll be able to fill in all the gaps. That's right. Simply not the case anymore. And USCIS has already signaled that skeletal filings will be denied. So as we're coming up to the grandfathering date now, they need a fully completed source of funds and package in order to submit. They're not going to get away with just like a little bit of documentation. Like they will consider those legal deficiencies because you haven't mapped portions of that filing out, and they'll deny it. So it's very clear that that's sort of the important thing to them now.
Right. So do not consider a skeletal filing as a temporary way to get something in the door before the grandfathering deadline in hopes that you'll, receive an RFE later on and be able to continue. It seems like the important, point that you're making there is approvability on filing. Expect to file a petition that must be fully viewed as approvable with all this scrutiny at the time that it's filed, not planning for RFEs later on or being able to provide more documentation later on. Assume that if it's not perfectly approvable on filing, that you may well get a denial.
Absolutely. Yeah. And USCIS has made that clear that that's their stance.
Got it. Well, thank you so much for joining us. We really, really appreciate it. I think that it's important for, potential investors to understand just how intense this process can be leading up to the grandfathering deadline, and how important it is to plan for a lengthy, detailed source of funds process and how that should impact their project timing as well. So, really appreciate your opinions and your thoughts on all this. And I want to just give you a moment here to, let people know where they can, find your services. If you want to provide a website or a way to get in touch with you, we'll just kind of turn the floor over to you to offer that up.
Absolutely. I appreciate that. Yeah. So you can find us at jetglobalsolutions.com, as well as I'm Ricky Murray in LinkedIn. I'm available there as well. You can look at that. Yeah, my firm, really, we have government service as our priority. We had been government employees, all of us, for about 20 years each, and now we're turning that over to the private sector and really trying to improve the process for investors and for anyone else trying to go through the immigration journey.
Perfect. Well, once again, thank you so much for joining us, Attorney Murray, and I'm sure we'll speak again soon.
Absolutely. Thanks so much for having me.